Termination statements release a lender's security interest in collateral. Motors Liquidation Company explores what happens if a termination statement mistakenly identifies the wrong security interest. In 2001, General Motors entered into a synthetic lease by which it received approximately $300 million in financing from a syndicate of lenders, including J.P. Morgan Chase Bank. The synthetic lease was secured by liens on 12 parcels of property. The financing statements for the synthetic lease identified J.P. Morgan as the secured party of record. General Motors later entered into a separate term loan that secured approximately $1.5 billion in financing from a different syndicate of lenders. The term loan was secured by liens on, among other things, equipment and fixtures at 42 General Motors properties. Multiple financing statements were filed to perfect the lender's security interest. The most important financing statement was filed in Delaware and covered all the relevant equipment and fixtures. J.P. Morgan was again identified as the secured party of record. General Motors subsequently decided to pay off the synthetic lease. It instructed its counsel to prepare the documents necessary to release the interests that the synthetic lease lenders held on its property. Counsel mistakenly identified the term loan financing statement as one that should be released. Both J.P. Morgan and its counsel reviewed draft documents that identified the term loan financing statement but didn't catch the error. J.P. Morgan assented to the filing of the documents. General Motors then paid off the synthetic lease and filed the term loan termination statement with the Delaware Secretary of State. The error went unnoticed until General Motors filed for bankruptcy. J.P. Morgan then notified the Unsecured Creditors Committee of the mistake. The committee commenced an action against J.P. Morgan in bankruptcy court and asked the court to hold that the termination statement had effectively terminated the term loan security interest. J.P. Morgan argued that the termination statement wasn't effective because it didn't intend the statement to terminate the term loan security interest. In making this argument, J.P. Morgan relied on a provision of the Uniform Commercial Code that provides that termination statements are only effective if the secured party of record authorizes the filing. The parties filed cross motions for summary judgment. The bankruptcy court found in favor of J.P. Morgan and held that the filing was unauthorized and therefore ineffective. The committee appealed to the Second Circuit.